Hi, my name is Julia Lemon and I'm presenting a presentation on the topic of implied terms, section 13 through 15 of the Sale of Goods Act 1979. Introduction. This presentation will outline the implied terms of section 13 through 15 and how the sellers have to abide by them. I'll also go briefly through the remedies available if they are breached. The status of the implied terms of statutory rights. Contractual terms are either conditions, warranties, or innominate terms. The terms applied by the Sale of Goods Act 1979 are expressly classified by the Act as being conditions or warranties. Sections 13 through 15 are all conditions. If a condition is breached, the buyer can treat the contract as repudiated, reject the goods, and claim damages. However, if a warranty is breached, the buyer cannot repudiate the contract or reject the goods, but they can claim damages. However, if the breach is so slight that it would be unreasonable to reject them, then they can't reject the goods. Section 13(1), correspondence with description. It states where there is a contract for the sale of goods by description, there is an implied term that the goods will correspond with the description. This section ensures the seller will have an obligation to make sure the item is sold as described. For example, if you sell a shirt that's blue but send a pink one, that is a breach of section 30 subsection 1, as description is inaccurate. In Joseph Travers and Sons Limited versus Longall Limited, Lord Justice Sellers said that there are two types of contracts for sale of goods by description: unascertained or future goods or specific goods. Unascertained goods is one where the buyer relies on description alone, as they have not seen the product itself. Historically, specific goods is where the buyer could inspect the goods himself and determine whether or not it fits the seller's description. Now the sale of goods contract relates solely on specific goods. There are three limitations. The description must identify the goods, the buyer must rely on the description, and third limitation is the only descriptive words from the contract will form part of the sale by description. Section 13 subsection 1, limitation 1, identification of the goods. Descriptive words that the section relates to are only words linked to the goods identity and to the goods attributes such as quality and fitness of purpose. The case of Ashton Pickeries Limited versus Christopher Hill Limited conveys how the goods identity and attributes is relevant in deciding if the term applied by section 13(1) has been breached or not. In this case, a mink breeder contracted to purchase from Ashington a consignment of food to feed its mink. Ashington added a preservative to the food which reacted with the food, which would be okay for most animals but not mink. So lots of their mink died as a result. Christopher Hill refused to pay as huge breach of contract. The breach alleged was section 13(1), 14(2), and 14(3). The House of Lords held that the implied terms as to statutory quality and fitness of purpose had been breached, which is section 14(2) and 14(3). Term 13, however, had not. Lord Guest stated that the different substance from the herring meal was contaminated but did not result in a different substance from the herring meal in the original description, so there was no loss of identity here. Section 13 subsection 1, limitation 2, reliance. You must show that the buyer relied on descriptive words. In the case of Harlington and Leicester Enterprises Limited versus Christopher Hull Fine Art demonstrates this. In this case, both parties carrying out business as art dealers. Christopher Hull acquired two paintings by German artists. They contacted Harlington and asked if they would want to buy the paintings. When an employee was examining them, they claimed Christopher Hill knew nothing about the artist, as Harlington was an expert in this artist's work. Harlington purchased one for £6,000. It turned out to be a forgery. Christopher Hull claimed for breach of implied terms 13 subsection 1. Court stated that Harlington did not rely on Christopher Hill's description, but on the expertise of its own employees, so there was no breach of this implied term. Reliance is important in cases where the buyer relies on the description of the goods before purchasing them. In the case of Varley versus Whip, Channel J said that the term sale of goods by description must apply to all cases where the purchaser has not seen the goods but is relying on the description alone. Even shopping in person reliance is still important, as shown in Beale versus Taylor. This is when a car was advertised for sale, but it turned out to be two separate pieces of a later model of the car welded together. When the buyer made his offer, he relied on the description given in the advertisement and the badge showing it's from 1961, so court held Beale was entitled to damages as the entire car was not what the description claimed to be. Section 13 subsection 1, limitation 3. The description must constitute a term of the contract. This means even if the buyer relies on the description of the goods, it is still necessary to make sure the description constitutes a term of the contract. This element is shown in T&J Harrison versus Knowles and Foster, and this is where the court rejected the claim. So in this case, Knowles and Foster wished to sell two steamships to T&J Harrison. They provided them with all the particulars of the ships, which stated the deadweight capacity of each ship was 460 tons. T&J relied on this, and a contract was made. The contract had no mention of the ship's deadweight capacity, so when the ships were delivered, the deadweight capacity turned out to be 360 tons, and the court rejected the claim as the deadweight capacity may have induced T&J Harrison to enter the contract, but there was no breach of contract as it wasn't stated in it. If the descriptive words are nothing more than representation, there will be no liability under section 13 subsection 1, and the buyer can make a claim in another area such as misrepresentation. Even a slight deviation from the description can result in a breach, which is what occurred in Acros Limited versus E.A. Ronason and Son. So here, Ronason contracted purchase from Acros a number of timber staves to be used in the making of barrels. They were supposed to be 8 of 16ths an inch thick. When it was delivered, they were 9 of a 16th inch thick, which did not make a difference to the use of them. House of Law stated that the majority of the staves did not match the description, so term employment 13.1 was breached as the goods did not match the description. However, they still rejected the staves and terminated the contract. House of Law stated that the majority of the staves did not match the description, so term implied was breached, and as it did not match the goods description. The remedy is Section 13.1, and the buyer can reject the goods, repudiate the contract, and recover damages. Section 14.2 covers satisfactory quality of goods. It states that when the seller sells goods in the course of a business, there is an implied term that the goods supplied under the contract are of satisfactory quality. This requires goods to be of manageable quality. The case of Henry Kendall and Sons versus William Lillico and Sons Limited is an example where this was not breached. There is an objective test that the goods are satisfactory quality. If they meet the standard of a reasonable person, they are regarded as satisfactory. Take out of any description of the goods the price to any of the relevant circumstances. Section 14.2b provides a list of 5 aspects of quality taken into account to determine the quality of goods. Those 5 are fitness for all the purposes for which goods of the kind in question are commonly supplied, appearance and finish, freedom from minor defects, safety, and durability. Section 14c protects the seller if the buyer is made aware of a defect on the good and they still buy it, the buyer cannot claim for a breach of this statute. Thane versus Annie's Land Trade Centre is when Thane purchased a second-hand Renault car from Annie's Land Trade Centre, and 2 weeks after the purchase, there was a gearbox failure and the trade centre would not replace it. So Thane rejected the car and sought recovery of the purchase price on the grounds it wasn't satisfactory quality, and the court held that it was not breached as second-hand cars have increased risks attached to them that they are used at a lower price. The remedies are the same as Section 13. Section 14.3 Fitness for Purpose. It states that when the seller sells goods in the course of business and the buyer expressly or implication makes known to the seller or credit broker there is an implied term that the goods supplied under the contract are reasonably fit for that purpose supplied, except where circumstances that the buyer does not rely or that it is unreasonable for him to rely on the skill or judgment of the seller. Sold in the course of business covers sales that are integral to the business, and goods supplied under the contract means the goods sold will constitute the goods under the contract. There are 2 elements included in the statute, and that's communication for particular purposes and reliance. Communication for particular purposes is where the purpose for which the goods are bought is obvious or the goods can be used for several purposes. The seller will have the knowledge of this, and it does not need to be expressly stated. Where the buyer acquires the goods for an uncommon purpose, the term 14 theory will only be implied if this is communicated to the seller. For example, in the case of Griffith versus Peter Conway, Griffith purchased a tweed coat from Peter Conway, and she developed dermatitis as she has sensitive skin. This was abnormal, and so she claimed the coat was not fit for the purpose, and the claim failed as she did not make it known to the seller. Reliance is where the buyer relies on the skill and judgment of the seller or credit broker. As all rights said, reliance is inferred from the fact that the buyer goes to the shop thinking the seller has a knowledge and skill in selling their stock. Presumption can be rebutted by showing the buyer did not have reliance. And partial reliance when both the seller and the buyer have knowledge of expertise in the goods. There are 3 questions identified in Jewson versus Boyhan to help courts here. Firstly, whether the buyer had made known to the seller the purpose for which the goods were bought. Secondly, if they were reasonably fit for purpose. And thirdly, if they were not, whether the seller had shown that the buyer did not rely on their skill and judgment, and they would be unreasonable to do so. And the remedy for a breach of this section is the same as Section 13 and 14. Lastly, Section 15.2, Sale by Sample. This section ensures the bulk correspond with the sample and quality, and the goods will not have any defects which would have been seen as a sample of the good. The first one is found in Section 15.2a. This implied term provides that the quality of the bulk correspond with the quality of the sample. The buyer must have reasonably examined the sample of the goods. Visual examination is not defined here. Section 15.2 expands on Section 15.2a, saying that the goods must be free from defects. If it is, could have been found by reasonable examination, then it will not apply. Section 14.2c will take place if examination was done, and Section 15.2c will apply whether or not examination was done. Presenting a good in a shelf is not good enough to show the sales by sample. Visual examination can be merely looking, inspecting the good, or a more detailed examination. There may reveal material differences in products. Contracts have an express term stating that the sale is won by sample. In some practices, a simple visual examination may not be a breach of Section 15.2a, but other areas it could be, such as scientific areas. In E&S Rubin Limited versus Fairbros & Co. Limited, there was a breach of Section 15.2a, even if it could have been sold by warming them up. In Goldie versus Perry, the catapult was of matchable quality, so Perry breached the term by Section 14.2. Burton and Gray and Bros breached the implied term of Section 15.2c as a defect was not apparent on a reasonable examination. The remedies are the same as Section 13 and 14. Thank you for listening.